Yes, Akash will be starting in a couple of minutes. People are joining.
Sure, sir.
Okay, sure. So Amit is there, so Amit will be introducing you, and then we'll start.
Sure, sir.
Sir, should we begin?
We'll start after a couple of minutes.
Okay, sir. Sure.
Yeah, sure.
Sir, Akash, sir, with your permission, should we begin? Akash, sir, are you there?
Yes, please begin.
Okay, sir.
Can you share me?
Okay. Thank you so much, sir. So, good evening, everyone. I welcome you all for this fourth day of this capacity building program. And for this session today on alternative dispute resolution, we have with us Mr. Akash Gupta, who is an assistant professor and assistant director of the Center for Alternative Dispute Resolution at the Jindal Global Law School. He also teaches arbitration as a visiting faculty at the National Law School of India, University, Bangalore. He did his LLM in International Commercial Arbitration Law from Stockholm University. In 2023, he was recognized as the Young ADR Academic of the Year by the Asia Pacific Center for Arbitration and Mediation. He has authored a number of books. He has authored 20 publications, which are published by renowned publishers such as Sage, Springer, Routledge, and Thomson Reuters. Beyond academia, he actively volunteers as the arbitrator and judge in moot court and ADR competitions, including BIS, JESUP, and FDI. He has also conducted workshops at over 50 law schools across India. Since joining Jindal Global Law School in 2019, Sir has held several editorial as well as advisory roles with leading arbitration and law reviews. So, Sir is going to take today's session on alternative dispute resolution. And before I give this floor to Sir, I just wanted to request to all the participants to keep their mic on mute so that we don't have any intervention in between. And if there is any question, then they can pose it in the chat box so that we can take them at the end of the session. So, over to you, Sir.
Thank you very much. Thank you very much, Kalpesh sir and RGNUL team, ma'am, for having me here to take this session on the teaching of ADR. So before I start, are you able to see my screen?
Yes, sir.
Okay, perfect. Okay, so this is the structure for the discussion today. So please feel free to stop me if you have any questions, and you can use your microphones or you can just write on the chat box. Whenever you have a question, we can discuss it. You don't have to park it till the end. So in the next 55 minutes or so, we'll be having a discussion based on my presentation. You can ask questions, after which we'll stop for another set of question and answers. So let's start with this on teaching of ADR. How do we do it as a clinical subject? How we do it in a better way? But before that, the question is how, like, what is the need for having alternative dispute resolution as, one of the core courses? So in this session of 1 hour, what we are going to talk about is why ADR is important. What is the recent trends? What is the potential for ADR teaching methods? Syllabus. What is the prerequisites for ADR teaching? International approach, assessments, classroom discussion. So let's start with the first one. Why ADR is important? Anyone who wants to answer this? Why do you think that in given this 2 weeks online capacity building program, if there is a session on constitutional law or international law, these are one of the most famous ones, departments of law. But why do you think ADR is important? Because ADR is not in the preferred dispute resolution, as in like the state doesn't say that it's mandatory. The mandatory dispute resolution is litigation. The state courts have the power. So why do we say that ADR is important, or why we have to discuss this even in this platform? Yes, I can see a hand, Nitesh. You can unmute and answer.
Yes, good evening, sir. Sir, I think so that ADR is important because ADR is no more alternative dispute resolution. It is appropriate dispute resolution these days. And even the government of India is emphasizing. The ex Chief Justice of India, Honorable Mr. Chanchud, said that government, which is being the biggest litigator, should use mediation before approaching the honorable courts for resolution of disputes. So the government is realizing the potential of ADR, and we are now recognizing different ADR means like Truth and Reconciliation Commission, and we are talking about establishing a Truth and Reconciliation Commission for Jammu and Kashmir, so and forth. So we are realizing the power of ADR.
Okay, very good. Anyone else who want to share your views? So Dr. Gurdeep is typing on the chat box for timely and speedy disposal. Yes. Yes, Akansha?
Hi, sir. Good evening. I'm also presently teaching ADR in a law college. So I feel like that because of considering the fact that how the ease of doing business in the ease of doing business index, India is not really ranking, in the top. So to increase also the ease of doing business in India, we need to improve the laws in such a way that, India attracts foreign investment as well. And, India attracts people from outside to choose India as a forum to, specifically if we talk about arbitration, then they choose India as a forum to conduct their arbitrations.
Okay, on point. Very good. So now we see Dr. Gurdeep saying timely, speedy disposal. Nitesh is, Mr. Bhatt is saying that we require this because there are so many litigations pending, including the government of India as one of the party. Then you have Professor Akansha saying that for ease of doing business index, to improve our rankings, to make it more suitable for having more business, more investments coming into India, we need this. All of you are right. Now, let's spend some time in understanding that all of you are right. If you connect all the three answers, we'll also connect to the current slide. That we have a backlog of cases. So in India, there are pending cases which are 4.3 crore cases. I think now it's 4.5 CR. It's not even 4.3. There are so many judicial intervention in ADR matters. For example, even if you have an outcome of the ADR, still for enforcement, you have to go to the court, and the court interferes so much that it takes time. Commercial parties are not able to enforce the contract. Now, this is something which Professor Akansha has referred to. Ease of doing business index is one of the rankings where all the different states submit their reports based on which there is a ranking. Now, if you look at the Indian ranking, the last ranking, there are 10 criterions within which you get points. One of the criterion is enforcing contracts. Enforcing contract means that, let's say if a party breaches the contract, whether the other party is able to enforce it. How you enforce contract? Through dispute resolution. Now, if you are not able to realize an arbitral award, realize a mediation settlement agreement, if you are not able to go to the court and get a resolution, dispute resolution, you get a very low ranking. So India's ranking has improved tremendously in the 9 criteria, which is almost like India's rank. I think it came from 150 or something to around 60 plus, the overall ranking. However, if we look at the dispute resolution, enforcing contract ranking, India's rank has improved almost like 6-7 ranks. So India is still lacking behind in that. So now these are the things which actually indicates the importance of this alternative dispute resolution as a subject matter. Okay. Now let's go to the next part. That what are the different, recent trends which are happening, and then we'll move to the syllabus drafting of the syllabus part. Now, if you look at the recent trends, there have been so many Indian companies, 90% plus companies, which choose arbitration. Indian parties don't choose India as the seat. Ease of doing business index, which I was referring to, India's current rank, the last ranking release was 2019, 62nd, from 2014, 134th, which is a good improvement. However, India's ranking in enforcing contract was still 163rd. There have been a lot of online dispute resolution platforms which are doing online dispute resolution, including arbitrations and mediations. So if you look at the one of the platforms, Sama, it has more than 86 lakhs cases, out of which 16 lakhs cases were settled. Any question before we go to the next part? Anyone? Okay. Now, if you look at the potential area teaching methods, so there are so many different methods, but I have made 3 compartments. First is theory-centered method, where you actually apply the law to sample arbitration agreements and the case studies. Second is learning by doing, which is more like you do role-playing exercises with a script of facts tailored for certain roles, which is more like you have a problem and then you try to do the role play, you share the problems to the students, then the students actually start negotiating, mediating, or you share them a problem based on which they have to file a statement of claim. So this is what we call learning by doing. The third one is observing real life area cases. Allowing students to observe actual or simulated arbitral proceedings can greatly benefit their legal education. So first one is the theory centered, which is very simple, which all of us do in the class, right? That you start teaching what exactly is arbitration agreement, what is the validity of arbitration agreement, which law is applicable for the validity, which law is applicable to the arbitrability, all these different things. Second is when you actually ask them to do something, for example, role-playing exercises, or where you have something called, you give them a scenario, you give them a set of facts, and then they have to actually role play. So this is what I put it in the second compartment. The third compartment is when you actually take them to some real life case hearings, or you have a mock arbitration or something of that nature. So in total, there are 2 ways. One is, of course, what you teach is the theory part, but the other one is more inclined towards the role playing, or towards, what I call is using real life cases, or you do a dummy case and you ask your students to work upon it. You must have seen in the recent time there are also a lot of competitions with respect to arbitral award drafting and stuff. So this is something which I put in the second or the third category. Now let's go to the next part of syllabus drafting. Any questions so far, or any comments? Okay. So let's talk about the drafting of the syllabus. Now, there are 2 kinds of syllabus, which I call it dynamic syllabus and a static syllabus. Now, what is a static syllabus? That's pretty much easy. Let's say that you have to teach online dispute resolution or alternative dispute resolution, recognition, enforcement, any subject of area or mediation. Now, you get to teach this for the first time. Let's say it's 2025, Feb 1st, you have to start teaching. You get a course manual for this, and the course manual has been drafted in 2018. So let's say that some of the faculties who were teaching before you never updated it, you also don't update it, and you just teach that. That's what I call a static syllabus. That it's not even moving, it's not dynamic, it's not something which has been up to date. Now, there is a problem with a static syllabus. If you have an old syllabus, let's say of 2018, And if you teach the same syllabus in 2025, forget about 2018. If you teach 2021 or 2023 syllabus, in 2025 it's a problem because 2023 there was an NN Global which was exactly opposite of the Constitutional Bench judgment. The final outcome is that even if it is not stamped arbitration agreement or arbitration award, still it's enforceable. So there is a problem if you are not updating the syllabus every time. Then it's a challenge to ADR teaching because some of the things which you are teaching, of course, will be right because the basic principle remains the same. But some of the things which are trending, which are emerging topics, there may be a chance that it has evolved and now it's not the correct view of the law. Second, it also results in non-awareness of the students regarding the recent changes in the field. One of the example I just gave is NN Global. So for example, I'm teaching LLM, ADR in general currently. So when I teach a subject on ADR, I make sure that I also refer to the arbitration bill, which is released a month back. So if I don't teach that bill, that what is the proposal there, then there may be a chance that my students are going to miss out on what's happening currently in arbitration, right? So you have to make sure that you insert that within the syllabus. Another example, current example is the commercial codes amendment. So that is also something which you have to teach because that also has a portion related to arbitration. Now, these are the problems you'll face if you have a static syllabus. But if you have a dynamic syllabus, for example, you teach mediation with conciliation, which is a compulsory subject. Now, you teach the updated portions of law with the case laws. For example, Gayatri Balaswamy, constitutional bench case, which is pending in front of the Supreme Court. So you have to teach the previous Gayatri Balaswamy also and the current one that is pending. Mediation Act 2023, SEBI circular on ODR, let's say Keros blockchain dispute resolution, diversity in arbitration. So these are the things which you have to make sure, or let's say you have to include at least something on investment arbitration, its enforceability, sports arbitration. So some things which are actually catering to what's happening in the arbitration industry or area currently, because otherwise you will end up into having a static syllabus. Any question or any comment or experience or any problem which you have faced while you were teaching ADR with respect to syllabus or any questions so far? Okay, so if you don't ask me any question, I will be of the opinion that it was very smooth and it was very clear from my side. Unless until you ask me any question.
Anything?
Yes, please. I think two people have raised the hand. I'm not able to
Okay,
see
no
it,
problem.
Should I
but I think
speak?
two of you. Yes, please, please.
Sir,
Shkuntala
are
ma'am,
there any
I believe.
mood? Yes, someone else is speaking. Yes.
Sorry, can you go one by one? Yes.
Hello, sir. I have a question, sir, please.
Yes,
Please
please.
allow. Okay. Actually, sir, I think this dynamic syllabus is okay with us, but as according to our guideline and our course should be confined. So how can I avoid this static syllabus? Because to complete our assignment, at the same time we have to aware the student about this arbitration and conciliation, all these things. What should we do? Because the syllabus is static, but it is very good to offer the your dynamic syllabus. So what should how we are going to lesson plan our course? Because lesson plan is very important, and within a ambit we have to complete our course.
Ma'am, if I understand your question correctly, you are saying that the syllabus has been fixed by the university
Yes, sir.
and
Yes, sir.
you have been allotted to teach
The
it.
same
Now, because
time,
the
this
syllabus.
actual sir, in syllabus, they are just said that arbitration, conciliation, your good office, negotiation, all these things in a first unit. If I cover all these things, I think this is what one totally chapter, the totally what session is over. If we will just confine with all these things. So unit wise, you will go for that, or we will go to the dynamic syllabus. Which
Ma'am,
one?
I understood your scenario. So basically, you are saying that if the university fixes a syllabus,
Yes, sir.
which is not a very dynamic syllabus, but you want to teach it, so how should you teach? Whether you should follow unit wise, unit one, whatever is prescribed, or how do you actually insert the dynamic portions? So
Sir.
I understand it's a very difficult position when you have a university fixing the syllabus,
Sir.
and then you get the syllabus which is all drafted. You don't have a lot of room to do it. But I think there is a middle way of doing this. So when you teach those units, so let's say if one of the first unit is something like Mediation Act 2023, which doesn't go into the details of the section, but it provides an overview. So I think
actually, sir, they just give the mediation, and they also skip your commercial court Act of 2015. So how can we go for all these things, sir?
So I think I get your scenario, ma'am. So I think it's a bit problematic. However, there can be a potential solution, which is more like this: that when you teach, let's say, Arbitration Act, when you are teaching, let's say, Section 34, then you can actually refer to the Commercial Codes Act, that there has been special benches. You can also teach a bit on Commercial Codes, the pending bill, which provides for special benches for arbitration. So I'm not saying something which is very different from the syllabus. Instead of cutting down the syllabus or creating a different syllabus which is against the university guidelines, it's better to complement the syllabus with some of the things which I just covered. So instead of cutting it down, you should complement it. But I understand it's going to be a bit of a task as a faculty, because you don't have exactly a dynamic syllabus, but you are trying to influx some of the dynamic concepts within the static syllabus. So I think that's something which you can still do.
Actually, sir, in our syllabus, there is only one act two act is given: Arbitration Conciliation Act of 1996. Another one is your Legal Service Authority Act of 1987. This two act is we should confine to this act, this two act. How can we are going to employ all these acts, sir? That is my question.
Ma'am, I understand your scenario, but I think it's very difficult to answer this question. But I think it's the only way to make sure that the students also get to know what things are happening is you try to complement it, because I understand when the university provides that it's A or AB, not A, B, C, D, E. So you can't actually make mandatory questions also from that. So I understand the admin difficulty part, but I think it's still a better idea to at least give them some bits and pieces of the dynamic syllabus. And you can, of course, make a disclaimer that this is not a mandatory portion, because the university doesn't provide it. So technically, you can't ask them a mandatory question from there. But still, it's better to talk about this in the class. That's like my short answer to that. Thank you. I see another question on the chat box from Mr. Arora. What to do in those cases where the university has prescribed the syllabus and no amendment is allowed from the side of the college? Okay, I think I answered this. So you also have a similar scenario. So my answer remains the same. But of course, please check into your university rules, regulations also, like how it works. But I don't think it's a problem if you influx some of the things extra, but you make sure in the class that this is not a mandatory course, but this is more like a recent updates in the ADR. I don't think it should be a problem. But please check with your university. Any other question? I think two of you raised the hand. Did I answer both of you?
Yes, sir. One question is on my part sir, can you recommend some good movies and novels through which students can learn arbitration and mediation? Like I can show some movie to the students and then after some session based on it.
Yes, I can. So, but like I have to make a list because I use a lot of them in my class, but I haven't made a list. There are a lot of them, including Bollywood and Hollywood, a lot of series also. So if you can connect to me after this, I'll share you my videos at the end. And
Sure,
we'll
that
talk
would be
about
great.
There's a lot of them which you can do for you. I also use it. Yeah.
Thank you.
Another question? Okay. Now let's go to the next part. Okay. So syllabus part is, I will say it's very important to understand the dynamic versus static syllabus. And we had spent almost like 10 minutes on this. So now let's go to the next part, which is prerequisites of teaching India. Now, circulating the syllabus with readings, textbook, cases, and the platform. If you are not circulating it, the students should be aware where do they actually get these things. So if you are teaching arbitration, if you are teaching ADR, mediation, you have to make sure that your students also know mediation, Kluwer mediation blog, Kluwer arbitration blog. Then they should also know Jus Mundi. They should know Kluwer arbitration, because these are the places where they'll be getting a lot of articles to read. If they are not aware of it, it's your job actually to actually tell them that these are the resources. Because if you say SCC Online Manupatra, it's a very big repository of almost everything. I'm not saying that arbitration you will not find it. You'll find it, but it's all Indian arbitration cases. But SCC Online or Manupatra Live, these are all Indian. If you have to teach international arbitration, you have to make them refer to truer arbitration. Okay. So these things you have to make sure that they know it. Otherwise, if you presume that they know it, if they don't know it, then there is you have to build a bridge with the student. When I say bridge, it's the communication bridge. If you don't have that bridge built, high chances that the students will not be very much interested in your subject, because there is no bridge of communication. Because you have actually collapsed that bridge in the beginning itself, because you think that they already know it, where to find these articles, how to research, and they think that you are not teaching them. So make sure that they already know this and you guys are on the same page. So this is more like where you have to research on arbitration or mediation. Creating a window for doubts clearance. So for example, when I started teaching this, session, when I started to deliver this session, I said that if you have a question, please feel free to stop me and we can discuss it in the middle. A lot of faculties like it the other way, that after they end their presentation, then they ask question. You have to make sure that you are very clear with these rules of your class, that when you can ask questions, then you have to create a platform where these students can ask questions. So please make sure that you have that window of doubts clearance. Some practical experience with ADR, drafting of arbitral award, interim measure, mediation settlement agreement. This is something which you should learn before actually teaching this. So if you are already doing mediations or arbitrations, for example, I do it, so you already know a lot of these things personally. So if you know it, it's good. If you don't know it, then you have to make sure that you are involved with these things so that you exactly understand what are the intricacies of drafting interim measure, how you draft emergency arbitration award, how you draft mediation settlement agreements, all of this. Now, teaching ADR with practical insights, whether a client should go for emergency arbitration at the seat or file an interim measure in the respondent's domestic court. What is the cost benefit analysis, chances of settlement? Now, this is just an example that how you have to teach. If I have to teach you emergency arbitration, I'll create this scenario that if you need to get a relief, whether you will go for emergency arbitration at the seat, whether you will go to the domestic courts of the country where the respondent resides, which one of them makes more sense to you? Which one of them is better for cost? Which one of them is better for the client? Now, this is how you have to make sure that you teach. Instead of teaching it more like in an abstract idea, you have to also make sure that the student understand that what sort of questions they will get when they start working for these arbitration firms, right? Just a second. Now let's go to the next part. International approach is must. If I would have been, delivering a session in this capacity building program on, let's say, Indian Constitution, or let's say uh, labor laws of India, I wouldn't have said this, that international approach is a must. But for arbitration, arbitration is international. Why? Because India is also a party to New York Convention. India is also signed up to the ancestral model law. India has signed up to the Singapore Convention. So therefore, it needs to be there. That international approach needs to be there when you teach these, because India is a party to these international laws. Okay. So convention, the New York Convention is with respect to foreign arbitral awards. The Singapore Convention is with respect to enforcement of mediation settlement agreements. Ancestral model law is actually a model law for arbitration, which India also adopted. IBA guidelines on conflict of interest, India has actually inserted this within their domestic law, which is Indian Arbitration and Conciliation Act. So please make sure that you also refer to the landmark judgments within the realm of ADR, within the realm of international commercial arbitration. Because if you are not doing that, you're also missing out some of the very good reasonings, because the Indian Supreme Court is also doing that. Indian Supreme Court also relies upon the landmark judgments from London, from Paris, from New York. So you have to make sure that you also influx this, but don't overdo it, because at the end, the Indian courts also have a lot of detailed judgments on the arbitration principles. So all I'm saying is that you have to make sure that international touch should be there, so that you don't teach things which are only related to the Indian arbitration, but it has to be complemented from international commercial arbitration cases outside India also, because even the Supreme Court of India relies upon it. Okay. Any questions so far? Anyone? Okay, now here comes the most important part, because all of you will connect to this, that what students care most is about the marks and the attendance, right? So let's talk about the elephant in the room, which is marks, which is assessment. So there are different set of assessments which you can do, but the assessments are also something which has to be in line with your university or the college guidelines. So for example, in some places it's the faculty's discretion, some places the university has a very detailed guidelines that how you can allocate the marks. So there are different ways which you can use for the assessments. One is a pen paper test, which is followed in majority of the places in India, which is more like you have a question paper, these students have to write the answers within 3 hours, within 90 minutes, whatever. That's pen paper test. So let's spend some time on the exam of this kind, which is pen paper. So anyone who wants to share your teaching experience of area, that how you frame the question paper. So let's say, for the sake of this discussion, it's 50 marks paper, which you have to set for the core course area. How will, like, what is your experience with this? Do you think it should be MCQ? Do you think it should be short answer questions? Do you think it should be long answer questions? Do you think it should be only theory based questions? Do you think it should be problem based question, or something larger, which is more like mini moot problem questions? Anyone who wants to share your experience so that we can build upon that discussion? Yes, please.
Sir, I prefer short and medium questions with 60% weightage to situation-based question and 40% theory-based question for my weaker students who are not that smart to apply that.
Okay, very good. So Mr. Bhatt is saying that he has a blend of 60% problem-based, 40% theory-based questions. So do you also use MCQs, or you don't use MCQs?
I use MCQ, sir, in the assignments, not in the periodical and final test.
Okay, so basically you're saying in the finals you don't use it, but for the internals you use it.
Yes, I do.
Anyone else? Okay, so Mr. Arora is saying...
Sir, actually, for internal, we are using MCQ, and also in 40 marks, we have a practical. Unit wise, we will giving the exam question answer and with case law, sir. So our
so this exam is pen paper within like 3 hours or something, right?
no, sir. Pen paper exam is your 48 marks, sir, and we have a 7 marks internal, 5 marks attendance, and 40 marks, sir. Unit wise question we are giving, and there is the assignment, and according to unit wise we are giving, and with case law they are assigned all these practical papers.
Okay, so now we have seen different set of question paper style. So mood type questions on the chat box, referring to previous year question paper, all theory questions. Now let's spend some time in understanding how test should work out. So I think MCQs are going to be very direct. So instead of that, it's better, because the idea of an exam is that the students apply the concepts which you have taught during the semester. So the ideal way of testing them, instead of having them a good memory, You give them a bare act. If you think that bare act should be given, it's too much of, too many sections for them. So what you do, you create more like, which you call it hypothetical questions, mini mood problem questions, or scenario based questions, where these students have to use those particular principles of law and they have to apply. But there is a catch in those questions. Some of us, some of the faculties, some of us think that, let's say if there is a scenario, let's say it's based on modification of arbitral award. Let's say that I teach in my class that modification of arbitral award is not allowed. I teach, let's say this case Sanyong, where modification of arbitral award was done, but I say that this is not the international approach, and section 34 of the Indian Act does not provide for modification power, it only provides for setting aside. If a student writes my view, it's a hypothetical. So I give that person 10. But if the student writes that no, this is not correct, technically the Indian Supreme Court has already done that in the Sanyong case, and Article 142 of the Indian Constitution gives them the power to do complete justice, and they have done it. I mark them low. Now, this is one of the problem as a faculty teaching ADR. Please be mindful of this. In these kind of scenarios where you have two potential answers, even the Supreme Court has set up a constitutional bench on this, that whether we have the power to modify or not. In these scenarios, instead of looking at the interpretation A or B, saying A is right, B is wrong, what you have to look into the reasoning of the student. It doesn't matter whether the student writes your view A or the opposite view B, but you have to look into the reasoning. Majority of the times we think that it's one answer, but here there are two potential answers. But if I ask you that whether the Indian courts can set aside an arbitral award rendered outside India, let's say the seat was Malaysia, can the Indian court set it aside? There is only one answer. Why? Because Indian courts can only have the power to set aside when the seat of arbitration is India. Section 2 provides for that. Bhartiya Balko combined judgment provides for that. So please be mindful of this, that when you create hypothetical questions, make sure that the answer key reflects that both of the views are potential answers and there are these reasonings. If it matches the reasoning, then the student should be awarded marks for this. So this is what we call hypothetical questions, mood type questions, mini mood problems. So this will give a chance to the students to apply whatever legal principles that you have taught throughout the semester. This is the most preferred way of testing students. The second set of questions which we use, I don't personally recommend this because it's very wide and these questions are like on a very different standard. It's like very plain and flat questions. For example, theory questions. So when you ask theory questions, it's going to be very simple for the students, and if they have a bare act, it doesn't take a lot of time to find in the bare act and then write the answers. So theory based questions, unless until it's a mini mood problem, it's going to be very easy and you don't have to apply a lot of principles, especially when you have a bare act. So you have to make sure that it's complementing to what you have taught and it tests the principles which you have taught during the semester. So pen paper test, you have to make sure that there are different options, of course, but I personally like the hypotheticals or the mini mood problem questions, so the student gets a chance to apply the principles, which they have to eventually do it when they start working. But it's your call how it works for you or the university guidelines. Please check it out. But pen paper test is mandatory for a lot of law schools in India in the finals, not mandatory for the internals. Now, for the internals, you get some room to develop your own internal assessment. Now, what are those internal assessments can be? Now, these can be a research paper or a response paper, role plays, moods, debates, class discussions. So out of these, what I prefer more is a paper. When I say a paper, it shouldn't be a descriptive paper providing that, section 34 is this, section 34 provides for this, there is public policy, because that's a summary of a paper. Unless until you provide a fresh perspective or some analysis which adds on to the current literature, it's not going to add. The reason why I say that it has to have a fresh perspective, it needs to have an argument, it needs to have a response, because only then you'll be able to publish it. And unless until you publish a paper, there is no point of writing a paper because it's just a draft paper, right? So I personally use more papers in the internal assessments. The good part of this is that you also get marks during the internals. And if some of my students, for example, I'm teaching LLM ADR batch in general, some of my students got it published the last semester response paper. So apart from getting marks, you also get my feedback, you get the faculty feedback, you also get it published. So it's an outcome, it's a deliverable. Apart from your daily curriculum, you also get a publication. So this is something which you can try, having papers. But when I say papers, it shouldn't be descriptive papers. It should be a publishable quality. Okay. Role plays means a lot of faculties also do negotiations, mediations for assessment, and they divide the teams into different groups, like party A, client council, party B, client council. Then there are two mediators. Then you create a group of 6 plus 6 plus 6, and this is how you do it. Some of us also do mock arbitrations, but mock arbitrations take a bit longer because in that you have to have a written submission, then you need to have an oral rounds, and evaluations for mock arbitrations will take a lot of time because then you have to have written round, then you need to have oral rounds, and then a proper evaluation, which will take some time. Debate class discussions or class participation is also something which a lot of faculties do. So this is another thing which you can add, but that's not a separate assessment. It's more like a part of 5 marks or 10 marks or something on those lines. Any questions on the assessment? One thing which I missed, which I personally do, is using Kahoot quiz in my classes. So basically, Kahoot quiz this is how it works. So I use my slide. I put the questions there, and the students use their mobile phones. They enter the game. It's all online. They get the questions, 4 options, 30 seconds, and then they answer the question. So every time I teach them a module, I make more like 10 questions, 20 questions from the module, which acts more like checkpoints. So for example, when you play racing games, you have checkpoints through which you, so if you don't pass, it means that you are taking a shortcut, you're not following the route, right? So I use Kahoot quiz. It's live, it's all online, it's free, you can also use it. So you use this to make sure that I use it to make sure that my students understand what I taught. If I see that more than 50% of these students are not getting the right answers, and it's live, you can see it on the screen that how many students opted for the right answer, wrong answer. All of this is live. The moment it goes beyond 50% wrong answers, I understand that somewhere I have failed to make myself clear, and what I taught wasn't clear to them. So I revisit those in very short, and then I get the confidence of the student on that topic, and then I move ahead. So this is what I do personally. So Kahoot quiz, or let's say if you use another platform, but it has to be live so that the students do not have to wait for getting the right answers. It's very quick, like 30 seconds on the screen, the questions, options. They use mobile phones, they get all the answers right there on the screen. Then I do a mini discussion and I move. So I make sure that what I taught, the students understood. So it acts more like a reality check for me as well as for the students. So it's a win-win. So this is how I use MCQs, but these are not marked. These are not like they get marks for this, for the internals or something. But my students like it. So maybe you can also try it. Any questions so far?
Sir, what spelling of the quiz app you told? Kahoot? What is the spelling?
Type it on the chat box.
Yes, that would be helpful. Thank you.
It's very famous. It's very famous. I'm using this from the last 6 years. I'm teaching and I'm using this wherever I go. Students love it. So maybe you can also start trying it if you don't use it now. And it's very good. It's all live, and you also do this. So whenever I do it, it's like some people who don't know about this, some students, they like this idea that at least they know, they get a check that what they understood or not. Because sometimes what we think, the moment I teach something, I think that, maybe everyone understood it. But when I get 60% wrong answers, I know that, I wasn't that great because they didn't understood the concept which I wanted them to understand. So this Kahoot will actually help you with that. So it's more like a, feedback also, a very live feedback which will showcase you right there. So it's a very good Any other questions? Okay. Okay, so I didn't miss it in my slide. Kahoot is already there. I just thought that I missed it. Okay, now classroom discussions and engagement. Understand this. If let's say that I start taking this session and it's a one-way traffic that I start my discussion, I'm not giving you, chance to ask questions or give your comments, but it's one-way traffic. Maybe it works for some of the faculties, some of you will like it, but it does not have a very long attention span if it's a one-way, traffic. But let's say if we have a discussion, it's more engaging, it's less boring, and maybe you are more inclined to listen to what I'm going to say next. So I always recommend that the more discussions you have, the more engagement you have, it's going to help you out and your students also. So usually what I do when I teach ADR is that I start with a question. I create a scenario, I start with a question so that it gives them a food for thought in the beginning of the class, which is related to the module I'm teaching. So they are more interested to answer that, and then I start teaching. Instead of coming to the class saying that this is section 7, this is section 34, I create a scenario, and you start with this, that if there are two seats, one is a seat, one is a procedural law, which is applicable from a different state, then which one of them is a seat? And now we are going to learn what is seat, venue, place of arbitration. So basically, this is something which actually interests these students, that, oh, how can you have two seats? Can you have two seats? Now, this is something through which you start your discussion, or you give them a scenario that if the award is rendered in Singapore, can it be set aside? Now, just keep in mind this, and then now let's study section 34, and we'll answer this question when we are wrapping up this discussion on section 34. This is something which will actually help a lot in having more discussions instead of just following more like a one-way traffic, saying this is section 7, this is the case. The second thing which you can do to make sure that these students engage, if you think that these students are not engaging, not having a lot of discussions on the area topics, when you have the Kahoot, they don't have to engage to you personally, like one-to-one. It's very simple. They have a mobile phone, they have a laptop, tab, and they can just log in, answer the questions. And it's a very easy way of creating a bridge in between you and these students so that they also know how much they know. You also know how good you are. So this is just one example which I do Kahoot. I do other things also to do that, but this is one of the easiest one for anyone to use. And it's free, you don't have to pay for this. Real life examples, recent decisions of the courts, discussions on scholarly articles related to the topics. So for example, you must have read something on live law, a recent case which is so bizarre with respect to arbitration. If you can start that discussion in the beginning or somewhere in the class, that is something also which attracts the attention of these students, and you create a scenario from there, and then you start teaching the whole class with respect to that module. Now these are just some of the examples which comes to my mind which you can use for teaching ADR. But if I have to, summarize the main pointers are these. One is the syllabus, that it has to be updated. Two is that you need to make sure that the assessment pattern, what are the assessments, you have to introduce it as soon as possible. Maybe in the first class, you have to finalize this assessment, and please make sure that instead of instructing these students that this is my assessment, it's much better to discuss your assessment proposals, plans, or have their proposals, and you discuss it in class, and then you finalize after having a discussion with the students so that you get the confidence of the students also. So I usually do this, and the students are very supportive, and they of course help me finalize this in the first class itself. And you also finalize the deadlines. If you're not fixing the deadlines in the first class, it's going to be also a problem. So please make sure that you focus on the syllabus, you focus on the assessments, and you yourself keep updated with these things. Now, talking about how do you actually make sure that you are covering all the things which are happening in the recent times. It's fairly simple. You use something like SEC Online, Bar and Bench, Live Law. You already know the Indian ongoing things in arbitration, in mediations. If you have to follow the international news on arbitration, you have to follow international for international arbitration, you have to follow pure arbitration. For mediation, you should follow pure mediation. There is Jus Mundi, there is global arbitration review. There are so many. Okay, so these are the things where these are the places where you can actually make sure that you are updated, so that you can also update your syllabus. And you have to also motivate your students to make sure that they also follow these things, so that they don't miss out. Even if you are not able to teach that, but they already know it, so it's fine. It doesn't matter whether you teach it in the class or not. Okay, so this is something which I wanted to discuss, and now I open the floor for questions. And these are my contact details. You can scan the QR, you have my email ID. And if you want to have some questions or a one-to-one discussion, please feel free to write to me. And if I'm not able to answer your question, of course, please feel free to connect. Now I open the floor for questions. Any questions so far?
Okay, thank you very much, Akash. Any question, query, participant? You can
So
unmute
there is one
yourself and
question in
ask.
the yes.
Yeah.
There is one
Yeah, please
question in
over to
the
you.
chat box. Mr. Rahul has asked how to use Kahoot. Please help.
Okay, so it's very simple. So this is how it works. So Kahoot, you go there, you make your own account. Then you can create a quiz. So you put your own questions, you put 4 options. Once you are done, you just save it. And then whenever you want to play it, you just log in again. You just say play. And then the students will see a screen where you have this OTP, which they have to enter from any mobile phone. They don't have to make an account. And they'll log into the game. And then you just have to click start. And the questions will come 30 seconds. The results will come. You just have to go to the next question. So basically, it's more like a KBC of your own. It's that simple. And it's very simple. You have YouTube tutorials also. Or if you are not very good with this, if you have a problem, why don't you just text me? You have my details. So I'll help you. But I do this for the last 6 years, so it's very good. I will highly recommend.
Yes, any other question, participants?
Or maybe I
Sir,
was very much clear, so nobody has a question.
excuse me, sir. Sir, if there is a need of physical attendance of this arbitration proceeding, student, we will proceed for that. Hello.
I'm sorry,
We
I'm
have
not able to understand your question.
actually physically student will go to see this proceeding, sir. Attendance of this proceeding, arbitration conciliation proceeding, or not?
You are asking me that whether you can take your students to watch a real life arbitration proceeding.
Sir.
You can. So it depends. Let's say that you know the arbitral tribunal, whoever is the arbitrator, and they ask the parties, is it fine that if there is a cohort of students which want to see the proceedings? And if the arbitrator says yes, there is no problem. But you have to actually get in touch with the arbitrators for this, or a mediation center, or an arbitration center. There is no problem. People do that.
Okay, sir.
Yeah.
Actually,
But without
we are
the approval,
suggesting them, actually, sir, we are suggesting them, as they have an internship now, so they will go for this arbitration, go to
yes.
attend all this thing. We are suggesting
Yes,
them,
in
sir.
the internships, of course, they do. Yes.
Okay. Thank you, sir.
Yeah. Thank you, ma'am.
Okay. Any other question, participant? Then one question from my side, like, do you suggest we should also discuss conciliation, negotiation, is ADR? Now, only one paper was there. Now, mediation is also included. Again, that will be taken care in tomorrow's session. But again, do you suggest like we have to discuss negotiation, conciliation part, and then because there's no act for that particular, that part, other kind of ADR system. Uh, so how do you deal with those kind of subject, or we should how we deal with those kind of topics, this ADR subject?
So I got your question, sir. So when I teach ADR core course, I teach all of this. I teach arbitration, I teach mediation, I teach negotiation, I teach lok adalats, and our course manual provides for all of this. Technically, this is how it should be, because ADR is very wide, which includes all of this. But some people which I have seen in a lot of law schools, it's not covering all of them, and some of them are very overarching. So you have to make sure that you include all of this, unless until, let's say that you have a course Arbitration and Conciliation Act, then you have another special course on Mediation and Conciliation. Then it makes sense that you have two different subjects, two different faculties are teaching. But if it's just one course ADR in 5 years of your law school program, then you have to make sure that you teach all of this, because otherwise these students are going to miss out on this.
Yeah,
And there
definitely.
may be a chance that it's not included. Maybe when the syllabus was drafted, there was an error, which was not even intentional, but nobody tried to change it. So it's always better to include all of these, even if for negotiation there is no special law in India. For mediation we do have, for conciliation we do have, for lok adalats we have a law. But still, I'll say that for negotiation we should teach it. There is no problem with that.
Yeah. I was teaching one of the my previous institution. So that faculty student were complaining, sir, what is already taught in ADRs, like being taught in mediation, because they again the draft was circulated only for the comments, not they asked a law school to adopt that mediation, because at that time same thing, other subject also sometimes they float draft the course, or they include okay
Yeah,
this kind of subject. So again it was there, but again some people, some dean director, they started
I understand where you
adding.
are coming. I understand where you are coming from. So my short answer is what even ma'am asked me. Dr. Goda ma'am asked me this. My short answer is this: if, let's say, the syllabus provides for ABC and you cover ABC in addition, you think DEF is something which I should also teach. At least I should discuss it in short in class. My short answer is it's always better to include more recent things, different things. If you teach more, there is no problem. But all of us will relate to this. If you miss out of the three mandatory portions, one, C, there'll be complaints for sure, right? So it's always better to teach extra. Why do you want to go to a non-safe zone? So it's always better to teach the mandatory portions. Apart from those, you also include some of the additional things which you think it should be taught. So you get your job satisfaction, plus you are also trying to give something extra to these students, apart from which is mandatory subject or mandatory, you know, pointers.
Definitely. I hope faculty must be aware about bar council. They sent letter to all the law schools. Or sorry, it was not later. I would say it was no. I would say later for I would general notification, like how mediation should be taught. There will be the capacity
Yeah, there
building
was one.
program will be
That
there.
mediation should be a
So
compulsory subject. Yes,
yeah, and for that, for ecosystem, develop ecosystem of mediation, so capacity building
yes.
program will be there, and then so many things. Hopefully, in coming year, they will plan something at some regional level, or maybe institution level, and then uh, faculty will be
Sir,
trained in
even
that
defense
particular
study
field.
has been asked to be introduced in law schools by
Yes.
BCI recently.
So many things, like what to say. Yeah, definitely, yeah. So mediation again, this being a clinical paper again, hardly, like some faculty like Rahul stated, like all the
Yes.
theoretical part. So it's a clinical paper, like that's why this we I thought of Dr. Sangeeta, like we plan this thing, clinical paper, how to teach. Again, you are teaching theory, arbitration, and then some practical, more practical part will be there. I would say 70% or 75% practical part would be there. Otherwise, it's like other paper that what we are teaching, since very first year.
Sir, what a lot of us are doing nowadays is more like the mock arbitrations, which I was referring to. So you create more like a 60-page, 50-page moot problem, and then you circulate it to the students. So the students are divided into like a batch of six, where two of them are claimant, two of them are respondent, two of them are arbitrators. So you divide the whole class into six students, like six students group. So let's say if you have 60 students, 10 groups, then you ask them to file their statement of claim, statement of defense. After that, there is an oral hearing. After the oral hearing, the arbitrators have to also draft an award. So everyone will be marked on the written submission and on the oral submission, both. This is how it is being done in a lot of places, including here. However, there is only one catch with this. It's a lot of evaluation for a faculty. So if two of you are teaching, or let's say you have an external examiner is allowed, that's a very good option. Otherwise, you have to do a lot of evaluations. For 60 people, there is an oral, there is written. It's a lot. And you can't do it in one go because one arbitration hearing for 6 people will take some time. Then you have 10 to do. So these are the things which are already happening in a lot of law schools in India also. So a lot of people are asking you to draft arbitral award, drafting arbitration clauses, or creating a mini moot problems. However, this is actually something which takes a lot of time for the faculties also.
Okay. And then what we have like observe, all of you, I think must agree. Like we discuss about arbitral award, but don't we discuss arbitration like an agreement or drafting arbitral award? I think I don't know how detail is being discussed. We discuss provision, okay, this should be the content, but the actual, for example, we are teaching contract. So we are not teaching right what we discussed in earlier our session on Monday and Tuesday also. So practical thing like draft contract clauses, same thing, arbitration agreement, separate arbitration agreement, and then this arbitral award, right? So those kind of things that should be like discussed. I suggest.
Yes.
And recently I saw one of the news like EBC, they had a tied up for I think publication of arbitral award. They will publish.
Yes.
So
IC and STC online. Yes.
I see the arbitral award by
The Council of
ICA.
Arbitration has entered into an MOU with SEC Online that we are going to publish the redacted version, keeping in mind the confidentiality of the arbitral awards. We'll redact the important information, names and everything, amount, and we'll publish and make a repository with SEC Online.
Okay, not they will remove, not incomplete. What you are saying.
So basically, the name of the parties will not be there. The amount which is awarded will not be there. But the decision making with respect to arbitration things will be there.
Okay, so that will be a great thing, right? No, we
Practice, sir.
technically
Outside it's a standard practice. It's just that
standard
it's the
practice,
first time in India somebody is doing it.
yeah. No, actually, we can see like what actually looks like arbitration going inside things happen.
It's a very good point
Yes.
which I missed. So some of you who are teaching ADR, I'll share my experience. So usually this is already there in ICC Arbitration Awards, International Chamber of Commerce. So I actually use them to use it for my class. So there are so many arbitration centers which publish arbitral awards, including ICC. So it's already there. You don't exactly need an Indian center to publish it. Of course, if it's an Indian center which is publishing, for example, I think it's good. But in India, nobody publishes it. The first one is going to publish is ICA. So you can choose foreign arbitration centers which actually publish these. And please make sure that if you have any more questions which we couldn't discuss, please drop me a text or something and we can connect later. Because some of the things Professor Kalpesh is just giving me more pointers which I missed. So this is something which I missed. So it's already there. Please don't think publication of awards is started in 2025. It's almost like 20 years old practice. It's just that in India, it's happening in 2025. And this is an example of what I said, that we have to follow the international trend. The international approach has to be there. When I say international, it doesn't mean that everything. Some things are good, some things are bad. But publication of awards is of course good. Why publication of award is good? So that you understand that how the arbitrators are actually deciding. Because in India, how we know that how arbitration works is through the courts. But courts only get challenges, appeals from the lower court, right? You don't get to understand how an arbitrator thinks. For that, you have to look at the arbitral award, which Professor Kalpesh rightly pointed out. So please make sure that you use Jus Mundi, you go to ICC, website, you get these awards, and you start using them in your own class. Okay?
Definitely. I think last question from my side, because we're pushing. I'm pushing the conversation further. So, I can see a lot of we can relate arbitration with commercial part only most of the time. But then I can see in sports arbitration case is there. I think like Switzerland, CS, and then in IPR, WIPO also come up with the arbitration document and guidelines, and then it's other fields also I would say like consumer things. So what's your input on that particular part? ADR and other like Companies Act. This is the
Sir,
last question. Then we close.
you are referring to my published papers. One paper I published was sports arbitration in India. The other one is consumer area. So you are actually right that these are the things which are not well explored. And it's good that you pointed out this. A lot of time we think it's only commercial arbitration. So one paper which I wrote was sports arbitration in India, how we can develop it further. So because the Indian sports bodies do not provide for arbitration center, that this is the specific center which gets all the authority. You'll be surprised that 30%, only 30% of the sports federation in India provides for internal complaints committee under the Sexual Harassment Act. It's only 30%. 70% of these sports bodies don't even have an internal complaints committee. And we are talking about arbitration in India. So it needs to be regulated. That's one. Second, for consumer, there are laws. For example, the Consumer Protection Act provides 2019 that you need to have mediation centers annexed to the consumer forums. How many of them are operable? It's a question. So I have written a paper on that also. Now, all I'm saying is these are just two, broader topics which comes to your mind, but there are so many things. For example, maritime arbitration, fixing of baseline. Can it be arbitrated? Yes, it can be arbitrated. It's already happening. ITLOS has its own arbitrations. State arbitrations, you won't believe that India and Pakistan had a very successful boundary dispute which was arbitrated, which is called the famous, run of Kutch arbitration. It's successful. Both India and Pakistan that particular arbitral award. So it was a boundary issue near the run of Kutch part of India. So this was successfully arbitrated. There are so many different things. Investment arbitration. One of the things which Professor Kalpesh pointed out is IP, intellectual property arbitrations, WIPO arbitrations. You must have heard of this, these domain names dispute resolution. This is all ICANN, exactly. This is already happening. It's not something very new. It's very old. E-commerce disputes being arbitrable, e-commerce disputes being, mediated. All of this is already happening. And this is why I said that your syllabus needs to be dynamic also. If you're not including these in your last module, that there are other set of arbitrations also. For example, investment arbitration, sports arbitration, state arbitration, maritime arbitration. I'm not saying that all of them have to be taught in detail, but you have to mention this at some point in your course manual that the students are aware of this. Instead of, because if you don't teach this in class, and if they are not very good with, exploring these things on internet, they're going to miss out on those. So I will say that, and these are the areas where you can do a research and you can also get it published. The reason is because it's not very much explored from the Indian perspective. So my experience of writing on consumer area, which is published by Taylor and Francis, or sports arbitration paper in International Sports Law Journal, I think when I was researching, there was no paper on sports arbitration in India. There are a lot of papers on blogs, and everyone rewrites almost the same thing. So if you create a theory, which I tried to do it, that India has two arbitration centers, on both of them don't have a website. Both of them are not operating. They don't have a list of arbitrators. There is no cases registered. So if you have an arbitration center where you have no cases, it's good for nothing, isn't it? Now, once you get into these topics, then you try to write something fresh and then you can also publish it. But it's just that we are not talking about it, we are not writing about it, we are not including it in the course manual. So we are just being unaware. So this is the reason the first step, the first slide of my session was syllabus, because that's a roadmap which you have to create. If you fail the first step itself, it's going to be very problematic to follow the next part, which is like, prerequisites, creating assessments, evaluations, all of this.
Sure. Recently, let me tell you all the participants, Akash and I, we wrote people like startup in arbitration, so ADR. So for our book chapter, legal aspect of startup. So we thought of it deliberated, because there is again a couple of good points we have discussed in that particular book chapter, startups, ADR, because so many, a lot of things happens in startup world now. Startup is a buzzword, and then so hopefully we'll be able to share in coming days that particular book chapter, we both of us written few months back. So I think we should end here. I request Amit to give a photo water thing to Abbas. Over to you, Amit.
Yes, sir. Thank you so much, sir. It was really great listening to you. Sharing my personal experience, I had the ADR as one of the subject in my law school, but nobody taught me that way, the way you told us how to strategize. ADR.
Sorry, Abhi, let me tell you, Amit is is legal manager in Cotton Corporation of India. So, and yeah, what?
So we deal,
Amit,
yes,
yeah.
yes, we deal with ADR, and we also challenge a lot of ADR arbitration awards in the courts. So we are actually practicing arbitration and everything, but nobody taught us that way. So it is really important how we strategize our pedagogy when it comes to learning and teaching. So there are so many takeaways. I have taken note of so many points, but sharing one umbrella takeaway that we all learned today is that we learned how to strategize uh, in order to facilitate arbitration, mediation, conciliation, uh, and the learning in this regard as a clinical paper in Indian law schools. Uh, therefore, so it was really great listening to you, sir. Thank you so much once again. And I also take this opportunity to thank all the participants who not only joined but also participated really well during this session. It was not a one-way traffic, but we interacted with each other, and it was really a great learning experience for all of us. Thank you so much, one and all. Uh, Thank you, sir.
Thank you very much.
Sure, sure. We'll share the book chapter. It's in process. Sorry for it's delaying for months. Dr. Sankut
Sir,
knows.
I think we should put it on SSRM, the draft version of it, so that everyone can access it.
Yeah. So,
Yeah, and also
okay.
if you want the list or the papers which I discussed during the course or the books on ADR which I follow, please feel free to connect to me. I can share it to you later. And the book chapter also, I'll take care of it. I'll put it on SSRN, which is written by me and under the guidance of Professor Kalpesh. And we'll share you the link sometime later.
Sure.
Thank you very much.
Thank you.
Okay,
Thank you very much.
thank you.
Sure, sure, sure.
And all the
Bye.
best with the rest of your course. Bye-bye.
Bye-bye.
Bye.
Thank you. Thank you, Amit. Thank you, Dr. Sangeeta, all the participants for joining, and look forward to tomorrow's session.
Thank you, sir. Thank you, Amit.
Thank you, sir. Okay.
Bye-bye.
Thank you so much, everyone. Bye.
Thank you, sir.